Thank you very much, Justice Markman. Now our fourth panelist, Professor Jeffrey Rosen. Let me confess that long before being asked to participate in this panel, I actually, not that I wouldn't have raced to read the writings of the other three panelists. I did. Insomnia. No. I will confess, and I have told him this already, that I actually read something that Professor Rosen wrote before knowing that I was going to have the pleasure of meeting him here. And so I can tell you that I can recommend for not only readability and thoughtful thesis, but I can recommend, just because it's a great read for all of us who wish that we knew these folks better, but I urge you to pick up a copy of his book on the Supreme Court, The Personalities and Rivalries That Defined America. Before he wrote that book, he, like Professor Strauss, was a Marshall Scholar. We have two, can you imagine, two on the same panel. He also hails from Harvard, which is okay, being the Stanford of the East. But then he also got his law degree from Yale, and now he's a professor of law at George Washington University in the District of Columbia. And of course, we know that he is a well-written and well-read commentator and author, and also regales us on NPR. So we welcome here today Professor Jeffrey Rosen.
Thank you so much, Judge. Thank you to the members of the Federalist Society for inviting me. Like Professor Strauss, I am impressed and grateful for your openness to opposing points of view, your intellectual creativity, and it's always an honor to be here. I know I benefit from the conversation. So I've been asked to play cleanup, and my argument is this. There are theoretical ways of reconciling originalism and precedent, and we've heard very thoughtful attempts in that regard from Professor Rappaport and Justice Markman. But these are not the methods of reconciliation embraced by the members of the Roberts Court, whose attitude toward precedent has been described by Justice Scalia as one of faux judicial restraint, whose judicial obfuscation should discomfit originalists and non-originalists alike. And after exploring that provocative charge of Justice Scalia, I want to talk about why it's a convincing charge and why we should all care about it. The judge asked me to close by thinking, why is this bad for the court and bad for the country? So first, let's just remind ourselves that courts don't overturn constitutional precedents very often. Michael Gerhardt has a great book on precedent, and he reminds us that the Marshall Court did not overturn a single constitutional precedent. The Taney Court overturned only one. The Hughes Court, during the New Deal era, overturned 25. The Warren Court, which has been a boogeyman today, overturned 32, which was the most up to that time. But that was nothing compared to the record of the Burger Court, which overruled no fewer than 76 precedents. So if you want a boogeyman and like precedents, it's Burger, not Warren, who's your guy. And the Rehnquist Court overturned 39 precedents, actually a bit more than the Warren Court. What about the Roberts Court, and what is its attitude toward precedent? We have two unapologetic originalists on the Warren Court, on the Roberts Court, Justice Scalia and Justice Thomas. Now, they won't gladden the hearts of all members of the Federalist Society. There are some originalists, like Gary Lawson and Randy Barnett, Federalist Society icons, who argue that it's unconstitutional for the Supreme Court to follow a precedent that deviates from the original meaning of the constitutional text, period. That is a principled position on steroids. It's not one that Justice Scalia embraces. He calls himself a faint-hearted originalist because he'd sometimes allow judicial precedent or societal custom to trump the original meaning of the Constitution. But Scalia distinguishes himself from Justice Thomas in this regard, and he says, the difference between me and Thomas is that Thomas, would overturn any precedent that he thinks is wrong. I, Scalia, wouldn't do that because I'm not a nut, says Scalia. So this, call yourself a faint-hearted originalist with a non-nut theory of the Constitution, says only Justice Thomas really has the courage of his convictions and will carry originalism all the way home. Everyone else on the Roberts Court has a less strenuous view. What I want to explore with you today is that Chief Justice Roberts himself does not embrace either the Scalia or Thomas position. In his confirmation hearings, Roberts claimed to care more about precedent than originalism, describing himself not as an originalist but a bottom-up rather than a top-down judge, suggesting bottom-up judging included respect for stare decisis, and famously likening himself to an umpire. I have an interest in Chief Justice Roberts' vision of precedent because soon after he took office, I had a thrilling opportunity for me to interview him. He had just finished his first term. And during this interview, which ended up in the book that the judge so nicely plugged, The Supreme Court, The Personalities and Rivalries That Defined America, available in paperback, Chief Justice Roberts expressed frustrations that his colleagues were acting more like law professors than members of a collegial court. And he said, essentially, they were too principled in their devotion to their theories. He said the court should not be an academic exercise. It's important for the court and the country in this polarized time that we converge around narrow, unanimous opinions. And he said that he would try to persuade his colleagues to embrace narrow, minimalist opinions rather than 5-4 divisive, hardcore decisions. So I was very impressed with Chief Justice Roberts. Some people thought I was a little too impressed. I came home from the interview and my wife decided that I developed a man crush on Chief Justice Roberts, which is false. I just deny it in every way. How could someone like me have my head turned by an interview? But I have to say that I was distressed to see that the term after we talked, this is the 2007 term, the court was criticized by both the right and the left for a series of ideologically divided 5-4 decisions that both supporters and opponents called examples of faux judicial restraint. They were not openly overruling precedents, but they were reaching exactly the opposite result from what the court had earlier ruled in cases that were hard to distinguish. So there was the Federal Election Commission versus Wisconsin Right to Life case. A 5-4 majority strikes down a provision of the McCain-Feingold law that limited expenditures by corporations, a provision the court had upheld 4 years earlier in the McConnell case. But the majority opinion refused openly to overrule McConnell, leading Scalia to object in this terms. He said the principal opinion's attempt at distinguishing McConnell is unpersuasive enough, and the change in the law at works is substantial enough that 7 justices of this court, having widely divergent views concerning the constitutionality of the restrictions at issue, agreed that the opinion effectively overrules McConnell without saying so. This faux judicial restraint is judicial obfuscation, a powerful charge. But there were other charges of faux judicial restraint in Gonzalez and Carhart. The same 5-4 majority upholds a federal partial birth abortion law, although the court had struck down an almost identical state law in 2002, again not formally repudiating the Stenberg decision, but narrowing it, twisting it, according to the dissenters, in ways that just wasn't open and transparent. Basically, the dissenters felt like they'd been played for dupes. The precedent was not overturned, but it wasn't characterized fairly. And then there was Hyneman versus Freedom from Religious Foundation. The same 5 say taxpayers have no standing to pursue an Establishment Clause challenge to a faith-based initiative, even though the court in Flast versus Cohn had recognized the right.